The following is paid programming.
It's time to talk taxes.
New friends, new opportunities, new partners. EG Tax.
It's Ask the Tax Lady with Esther Gulius and EG Tax on News Radio 930 WBEN. To reach Esther now, call 803-0930. Toll free at 1-800-616-9236. And cell calls are free at star 930. And now, live from the WBEN studios, it's Esther Gulius.
Hey, everybody, this is the Tax Lady, and this is our hour to talk about taxes and money, and I'm telling you, we have such a great show for you today. If you're anybody that's going to get older, or if you have parents that are older, or if you're a parent who's getting a little older and you're wondering about what the heck to do because of elder planning and Medicaid and Medicare, today is your show. Our phone number is 8030930, 8030930, star 930 on the cell phone. And I got Tiff Fabian with me. Hey, Tiff.
I gotta be Chris. Hello, Esther.
Yeah, Chris is with his daughter playing soccer in Connecticut.
Right.
Chris is not playing soccer, though, right?
No, Gracie's playing soccer, and she's hopefully doing good as the goalie, and all thoughts are with her and Chris.
All right, and then our special guest is Jeff Katz, who is an elder care attorney, my very good friend. I'm so thankful that you came in on a Saturday, Jeff. Thank you.
Well, thank you for having me, Esther. I appreciate it.
All right, and so he is like, who can get free legal advice, right? Well, today is your opportunity. If you're somebody who's planning on getting older, who has parents that are getting older, maybe you're getting older and you're wondering what to do, 8030930, 8030930, star 930 on a cell phone. And we want to help you. And Jeff Katz's phone number, he's at 8604 Main Street in Williamsville, actually kind of Clarence, I guess. And his phone number in his office is 633-3363. But we are here, and we will help you with all of your elder care problems, your own situation, your parents' situation, how to have that conversation with your parents. And I have like 15 things you need to do before you die. That's a fun topic. First of all, it says, I plagiarized this, is take a physical inventory of all your assets and write them down, like your houses, your jewelry, your land, your cars, antiques, and make that available. Take a non-physical inventory of assets, CDs, IRAs, and investments, and write them down. List your credit cards or balances and other debts that you have, so that, remember, if you're not here, it's hard for you to tell somebody. As a matter of fact, the other day somebody called me and said, Esther, I think you have lost money at New York State. Mm-hmm. So I went to the New York State website, and I did. I had lost money. And so they sent me like $233. So
you got it already?
I got it.
Because I know who that somebody was. That was Christopher Fabian who called you.
So it was like $233, but it was a little deposit that we had at one of the offices, I guess from NYSEG or something. They didn't know how to get a hold of me. How can that be? But I guess the whole thing is, when you're preparing your estate, you have to realize that you're not going to be here, right?
That's correct, Esther. Many people just don't take the time, the effort, meet with the right people to get their estate planned. And if you don't do it, obviously it's too late when you're not here.
That's exactly right.
And the problems can be catastrophic.
I saw the other day that 60% of people don't have wills. Did you ever see that statistics?
I have seen that statistic, and it's probably accurate. Most people don't get around to planning their estate, and many people who don't get around to planning their estate can end up with an unforeseen consequence, the money going to relatives that they don't want, or the money going to the state in some way, and causing extra court cases and fees and all that sort of thing. So it is very important for everybody to get their estate plan in order.
And I don't know how else you get out of this world without, I heard a joke yesterday. The number one cause of death is birth. If you're going to be born, you're going to die, right?
No one gets out alive.
You don't get, and I try to practice what I preach. Every year, right after tax season, I spend a day in my office and doing this kind of stuff, doing an inventory. And I have a little thing for my daughter. If you're reading this, I'm not here. because it's important for people to plan and let people know what your assets are, because you don't necessarily, your children wouldn't necessarily know what your CDs are or what your assets are. And it's really important to have that.
What you're saying is right. Everybody should really take, as you said, an inventory, take stock of what they own. It's really a couple-step process. One is just what you said, is to inventory what you have, make a list, keep track of it, make sure your loved ones know where that list is so that they can find these assets.
That's
and then
true.
Secondarily, get the documents in place, whether it be a will or a trust or a power of attorney, to make sure that what you want to have happen with those assets is going to happen.
So we have special guest today, Jeffrey Katz. He's an elder care attorney. If you are somebody that has wondered about, do we gift the house to our kids? When do we gift the house to our kids? Should we give away all of our money now? Should we have this conversation with mom or dad? This is an opportunity for you to pick the brain of someone that I absolutely respect. He's my own attorney, and he is absolutely wonderful. 8030930, 8030930, star 930 on a cell phone, and we want to help you. Tiff, do you have a will?
We do. Yep. Chris and I, when the girls were younger, we did a will because, we travel and we had younger daughters. And so we wanted to make sure that if we weren't around, that our kids would be taken care of by who we wanted to. So that was our idea now, but we haven't updated our will, and we really need to do that.
Jeff, should you update?
That's a great question. People ask me that all the time. Certainly the first time that most people put together a will or estate plan, exactly what Tiffany did. When you have young children, you need to lay out a guardian for the kids, just in case, God forbid that both parents pass away. Who's going to raise your children? How's the money going to go to the children?
Yep.
Setting up a trust for them. So that's really the first time that it's done in most family situations. And then from there, it depends on life changes and complexities. It's not something that needs to be revisited every year, just when there's certain life changes. Certainly, I would say...
which life changes? Divorces?
Well, divorces, death of other family members, aging of the children, that's a very common one. So your children are young when you put together your first will. Then the children become older. So it sounds like probably what's happening with Tiffany's kids. Then all of a sudden you don't need a guardian for the children anymore. They're no longer under 18. So then you'd put in place a different kind of a will. You also want to make the other documents that go along with it, a power of attorney and a healthcare proxy, are, in my mind, equally as important to controlling what happens during your lifetime.
And because of what we do, we're involved in taxes, right? What I'll see is a spouse who becomes very ill, and the other spouse doesn't get a power of attorney. And so life is still going on. And I think that power of attorney, wouldn't you agree that power of attorney that both spouses should have in the event that something happens, so that she or he can administrate
absolutely
the assets that they would need?
Yeah, absolutely. I say everyone should have a power of attorney, and every client that I have ever seen, we create a power of attorney for them. And the purpose of the power of attorney is if the person is alive but incapacitated, no longer, as you said, a spouse or somebody without who's not married and having their kids, or somebody else, to manage their financial and legal affairs in the event they can't do so. And if you don't put a power of attorney in place, which is a relatively straightforward document, can be done in an attorney's office in 1 or 2 visits. If you don't do that, to gain control of the assets of somebody who's incapacitated is a very difficult, costly, and complex process.
Yeah.
So that's
but
why
do it now. Do it while you're well.
Absolutely.
Right?
Do it while you're well. It's easier. It's cheaper. It's
and that's
absolutely.
That's why I really was so excited about having you on today, because nobody likes the fact that life has its ups and downs. But unfortunately, when you're in your downs, that's when you really wish that you would have done something when things were good. And, it's just so important that you would do these things, because life goes on, and you want to make sure that you plan for those things, I'm Esther Gulius, the tax lady from EG Tax. We have special guest in studio, Jeffrey Katz, with Tiffany Fabian. And if you have any questions about estate planning, what to do, gifting the house, gifting the assets, this is your opportunity to get the best advice at no charge. 8030930, 8030930, star 930 on your cell phone. We're going to take a short break, and we'll be back with your questions on the other side. Sergeant Pepper. He's so sweet. He does the oldies but goodies for me, Jeff. All right, I'm Esther Gulius, the tax lady, here in studio with Tiffany Fabian and our special guest, Jeffrey Katz. Free attorney help, elder care advice on our show, 8030930, 8030930. We got a bank of calls. I'm going to go to Jean. Hey, Jean in North Carolina. How y'all doing?
Just fine. Thanks for taking my call.
What can we do for you, sir?
Yeah, it's a question for your guest, Jeff. Dealing with power of attorney, if I personally don't know of someone who would be responsible and be a good person to be my power attorney as I grow older, is there a way I can hire a company or some firm to do this?
When you're creating a power of attorney, you need to appoint somebody you trust, somebody who is going to be involved in your life. So the short answer to that is you really need to find a person, and for almost every power of attorney, probably 95%, it's a family member. If you don't have a person like that, then you need to have a trusted friend. There would be services that might be available, but generally speaking, a power of attorney would have to be, and I would always want you to find, somebody who's close to you, somebody who you can trust, somebody who's going to be there, because it really is a very personal job. They're going to take over potentially your assets. They're going to pay your bills, make decisions for you in terms of where you're living and things along those lines. So you want it to be somebody you're close to, and most everybody can find somebody. And if you dig deep enough, that's what I always encourage clients to do. Let's find the right person, and then that person also has to agree to take on that job for you, because it is a big responsibility.
If you can't find one, is there something called corporate conservatorship or something like that still involves just hiring a company?
Well, there is when you say the word conservatorship is actually done through a court, so that would not be a power of attorney, and certainly a conservatorship could be granted in New York State. It's an Article 81 proceeding where the court appoints somebody to manage a person who's in need, to manage their affairs. So that's always available, in my opinion, as a kind of the last
that would
case
be
scenario.
Something that somebody does to take over the assets of somebody, right?
They
would go to court for the conservatorship.
That's
But
correct.
the power of attorney is something that I would do because I trust Tiffany. I would say Tiffany's my power of attorney.
Correct.
Right?
And
Right.
then Tiffany
if she
would agree to
agrees.
do that. Yep.
But if, let's say, I didn't have anybody to administrate my bills, etc., and my brother says, gee, we're going to have to get a conservatorship. We have to go to court to get that. Then it becomes more expensive, right?
Much more expensive, much more time-consuming, much more complicated. So
Right.
power of attorney is certainly the first option. And Gene, I would hope that if you can think about it, you'd find somebody who could serve as your power of attorney, because I do recommend that you and all the rest of our listeners
Could you
pick one out.
ever have like a lawyer be your power of attorney? Or?
You can.
Okay.
You could pick a trusted advisor,
Okay.
a lawyer, potentially an accountant,
Right.
somebody who's close to you, who is involved in your life, who'd be willing to take on that
Okay,
responsibility.
Gene?
Okay, thanks a lot.
Thanks, sir.
Good question.
Let's go to Larry from Georgia. We got all these Southerners today. Hey, Larry, how you doing?
We're doing okay, Esther. Esther, a couple things on the last caller. I'm kind of in a similar situation. I want to pass this on. What I was able to find for my credit union was a corporate trustee, and that's just an idea for him to look into. I've got a few questions for Jeff.
Yeah, Larry.
Jeff, how's your daughter?
She's wonderful, I guess. Thank you. I have two of them, but they're both great.
They're wonderful, too. Okay, Jeff, my situation is I'm dealing with a major medical condition, which is treatable. I've got Medicare, and I've got Kaiser too, as my advance. So I've had a couple of medical tests at a hospital, And Jeff, I want to be sure that the hospital doesn't overcharge me and charge me, for items that are outside of my
your scope, your disease, your illness, your ailment.
Of my network.
Okay.
Right. So that's one. So what just I do? Now, of course, when you go to the hospital, they ask you to sign all these forms, blah blah blah. But what can I do to protect myself so they don't charge me for items that are outside of my network? What would you do?
Okay, well, I'd say it's a very good question. I'll be candid; it's probably outside of the scope of what I do on a day-to-day basis.
Okay.
Well, when we talk about healthcare, just to kind of bring it back, when somebody is dealing with the healthcare system, in terms of meeting with doctors and meeting with hospitals, there are certain things that should always be put in place. One is a healthcare proxy. The healthcare proxy would be your appointment, Larry, of somebody else, or to help make your medical decisions, and that person also can help with the medical billing issues. And so everybody should have a healthcare proxy
And
put
then
in place.
a MOLST, a medical order for life-sustaining treatment.
Correct. And New York State now has a MOLST form, and what a MOLST form is, it's very important. I would recommend that everybody has one when they have a serious illness. You don't in the first instance, when you're young and healthy, you put together a healthcare proxy. When you are no longer well and you're in an institution, be it a hospital or a nursing home, I would recommend that people put together a MOLST form. That's done under the supervision of a doctor because it's a medical order, and it's a medical order on life-sustaining treatment, which deals with the end-of-life issues. So Larry, those are the things that would really be need to put in place. In terms of your actual billing questions, I'm not sure. We'd have to take that one offline to try and figure it out.
Yeah.
So.
Okay, Larry?
I'm thinking you'd want to talk to the hospital and tell them what your concern is and interface with your insurance company.
Right, with your insurance company. Thanks, Larry. Have a good day.
Thank you, guys.
Bye-bye. Let's see. We're going to go to Tom in South Buffalo. Hey, Tom, how can we help you, sir?
I have a question for Tiffany. I was wondering, I have a 401k, Dual Fidelity Investments with my employer. There's 500 of those.
Okay.
I could just leave the thing alone, but I left work on December 7th of last year, 2016. And if I want some of that money, I have to roll it over into an IRA.
Mm-hmm.
The question is, I can't, they want me to go online and fill out this form to switch it over to an IRA, and I can't do that, so I had them send me the packet in the mail.
Okay.
And it's over my head, and I happen to be blind.
Okay, Tom, you can come to our office. You said you're blind?
Or he could mail it.
Or mail it to us, and what we'll do is we'll fill out the forms for you.
With you. We'll do like a conference call.
Yeah.
Oh, okay.
Okay?
Would that work out okay
can I give
for
you?
you?
Can I give you our phone number at the office, Tom?
6886 or something like that.
632-7886.
Yeah. I was close.
Okay.
Yeah, but then mail it, and then I'll call you, and we'll set up a time. We'll fill out the form together, Tom, if that's okay with you.
Yeah, because I didn't want to leave Fidelity. I just wanted to switch it over to an IRA,
Okay. We'll call you when we get the forms. Okay, Tom?
Okay, thank you very much.
Thank you. I'm Esther Gulius, the tax lady from EG Tax, 8030930, 8030930, star 930 on a cell phone, and we're talking with our special guest, Jeffrey Katz, who's an elder care attorney. If you have questions about gifting assets, gifting property, your elder care plan, your estate plan, anything to do with that, Jeff is your guy. 8030930, 8030930, and I'm going to go to Mr. Bill in Niagara Falls. Hey, Bill, how can we help you, sir?
Good. Esther, a question I have is we transferred my parents' house a number of years ago, probably 15, to the children's names. And now I understand that, we could have probably did something like a life estate because we've been paying the taxes on it all along. Is there some way that you can redo that and create a life estate after the fact?
The short answer to your question, Bill, is yes, but let's get a little more detailed. So basically, when you said, because you have information, obviously, which is what a life estate is. So when in the most common situation, the parents, mom transfers the house to the kids, that transfer can be either outright, which is what it sounds like your family's that transfer was, or it can be a transfer to the children where the parents, where mom and dad, reserve a life estate. And that life estate then is really a life interest or life ownership in the property, which then means that mom would continue to pay the taxes, mom would continue to live in the home. So if that that's the most common way to do it, and that also helps protect the house when we're going to talk about probably in the next section, protecting assets for elder law and if somebody needs to go to a nursing home. So in your situation, though, there is the capability to change the title on the house back. If your parent, is the person still alive who transferred the house?
Yeah, my mom is.
Yes. Does she still live in the house?
Yep.
Yeah. So if you and your mom agreed that she should have a life estate in that house, you could do it again. You could, we could create, you could now as the owner of the property grant her a life estate. There's pros and cons to that, so I'm not necessarily saying we should do it. But the short answer is, if that's something that you really wanted to do, it could be done.
Okay.
Okay, and obviously from a tax standpoint, if when mom does pass away, if it's in a life estate, then you get the stepped up basis, and you won't have to pay the taxes on the house or on most of it at any rate. So that's something to look at from a tax standpoint too.
Okay.
All right, Bill?
Thank you.
Thanks for calling. I'm Esther Gulius, the tax lady from EG Tax, 8030930, 8030930, star 930 and a cell phone. If you are wondering what the Medicaid rules are, how to approach a nursing home, if you have a family member that's looking at nursing home care, how to do that, when to gift the assets, when to liquidate your estate, this is your time to call 8030930, 8030930, star 930 on a cell phone. We have Jeffrey Katz, a specialist in elder care. We're going to take a short break. We'll be back with your calls on the other side of the news.
It's been 1 week since you looked at me. Cocked your head to the side and said I'm angry. 5 days since you laughed at me, saying get that together, come back and see
Hey, this is Esther Gulius. We're over here talking with Jeff and Tiffany, and I forgot that I was doing a radio show. I'm Esther Gulius, the tax lady, 8030930, 8030930, star 930 on a cell phone. We have Jeffrey Katz, an elder care specialist, an attorney that will help you with Medicaid issues. Let's talk about that. What is it that people need to be aware of in order to have their loved one or their spouse become Medicaid eligible?
Okay, so when we talk about Medicaid eligibility, Esther, what we're really talking about is paying for a nursing home. So when an elderly person needs to go to a nursing home, and many of our loved ones do, basically it gets paid for one of three ways. It gets paid for by insurance, which would be either health insurance, which pays for very little, pays for the rehab of an individual, or long-term care insurance, which of course would be a commercially bought product that would then pay all or part of the bill. After that, then, it's either private pay, which is a person's own money, or Medicaid. So Medicaid is the governmental program that'll pay for those who can't pay for themselves. And in order to qualify in Erie County, if you're a single individual, you have to have what is defined as, in essence, no money, which is $14,800.
Which is almost no money.
Which is almost no money. And if you're a married couple, meaning that there's one of the couple that's at home, called a community spouse, and then the other married individual, whether it's a husband or wife, is in the nursing home, the community spouse gets to keep the house, regardless of value, and gets to keep approximately $90,000.
So why is it the poor little single person is $14,000 and the couple is $90,000?
That's a good question. It's the government, because these are all governmental rules.
Right.
The government's determined that that's what the person, the community spouse, needs to stay at home.
Yeah.
And they're also allowed a much greater amount of income. If you're a single individual, basically no income. If you're a community spouse, they're allowed to keep basically $3,000 a month in income.
So here's the $64,000 question. When is it that somebody should start planning to put all this into effect? Do you do it when somebody needs to go in a nursing home, or it's sometime in advance?
It really needs to be done in advance. In Erie County, we have a 5-year look back. So that meaning that if something's transferred, previously we were talking about a deed with a life estate, so if a house is transferred away, everything that's transferred away within the last 5 years renders a person ineligible for Medicaid. So if we're going to be doing some elder law planning, we have a 5-year window that we need to try and get this done in advance of the long-term care. So if the question is when, well, there's no real right answer to that question, but certainly at least 5 years in advance.
So if you knew you were going to be sick 5 years in advance, but obviously, as you are a senior, as you become a senior citizen, that has to be a concern if you don't want to be a private pay patient. Now, I will tell you, if you are not Medicaid eligible and you're going into a nursing home, they are really, really expensive.
The cost of nursing homes now, it can be as high as $15,000 a month in Western New York. I can remember I've been doing this now for 30 years. When we started out, I remember telling people, "Can you believe a nursing home costs $20,000 a year?" So It's gone in 30 years. It's gone from $20,000 to $150,000.
So here's the thing. I mean, you want to make sure that you're pre-planning as much as possible. And if you are a senior and you have not done a will and you haven't had this conversation with your children, I mean, what would it cost to have somebody just come in and talk to you, Jeff?
Well, thank you for asking that question, Esther. Generally, when clients come to see me, the initial consultation is actually at no charge because almost everybody comes to see me. We can provide advice, and then we can do some sort of work. And then at that point, there'd be a fee charged, and I would tell them what the fee would be in advance, and then they would hire me to complete the work.
Right.
That varies from a simple will to a complex estate plan or to an elder law plan trying to protect the assets. But before anybody goes ahead, they'll know exactly what the cost is, and we go through it that way.
But the bottom line is you want to make sure that it's just like what we were talking about at the beginning of the show. You want to make sure that you think about these things because usually before you pass away, there's a period of illness. And many times it's in a nursing home, and it's really expensive. And if you're somebody that saved and saved and saved your whole life, your estate can go bye-bye in a very short period of time. I can think of one of my clients, Tiffany, I'm sure you've seen it too, where nobody did do the plan, and they didn't gift away their assets, and so what they basically was private pay patients up to the last.
Oh yeah, and it breaks your heart. It just breaks your heart.
Dollars, and so there's nothing left.
I see that almost every day in my office where a family will come in and a loved one is in a nursing home or is heading for a nursing home, and the question is, what do we do? And there's almost always something we can do. You can actually even do planning, elder law planning, trying to protect the assets, even if an individual's in a nursing home. So it's really never too late to come see the right attorney to try and protect the assets.
And I can tell you, Jeff Katz is the right attorney. I'm Esther Gulius, the tax lady. If you would like some information, if you're somebody that's thinking about an estate plan, worrying about what to do, now's the time to get some free advice. 8030930, 8030930, star 930 on a cell phone. We're going to go to Mary in Buffalo. Hi, Mary.
Hello. Hi, how are you?
How can we help you?
Well, I am 62, divorced. No children. Mm-hmm. How do you plan for the future with your assets?
Well, certainly, Mary, basically, when people have children, in most situations, their assets would be distributed to their children, and that's probably the most common type of estate plan that would be out there. I can certainly tell you that most of the most interesting estate plans that I create involve people without children because it gives you the opportunity to do charitable planning, charitable legacies, assisting members of the family. So, and in many ways, it's almost more important, very important for people without children to make sure they get the right estate plan put in place, because when you don't have kids, the process of passing one's assets can be very, very difficult, and again, can lead to more costly proceedings and can lead to problems.
Plus the healthcare stuff, too.
Absolutely.
Isn't it?
Again, when we talked about healthcare proxy and power of attorney again, so Mary, it'd be very important for you to determine who you would want to be making healthcare decisions for you, who you'd want to be your power of attorney to help you in the event you became incapacitated. So even though, lots of people, as you know, don't have kids, so it's very important to get those estate plans put in place. It's not like when Tiffany was talking about getting guardians appointed for the kids. That's what motivates you when you're a younger individual. But Mary, as a 62-year-old, this would be the time. Certainly, let's make those decisions.
While
get that
you're
done.
healthy and young.
Exactly.
I see a lot of people without kids. Nieces and nephews are the ones who will inherit their estate.
Absolutely,
Yeah.
loved family members, whether it's brothers and sisters, nieces and nephews. There's certainly people in your life you care about, Mary, that you can take care of in a way, and you got to put it in writing to make it happen. So.
And I never thought about that. That's true. When you don't have children, it becomes more cumbersome, perhaps.
Absolutely.
Yeah.
That could be a much more complex process to distribute those assets.
So did that help you, Mary?
Well, it did, but there is a will, and there's all of the nieces and nephews are out of town. So one of the nieces, I have her as the executrix and the beneficiary of all assets, so that she can divide them appropriately at the time of my demise.
Right.
But is that going to be onerous and tax consequences on her?
Yeah, the tricky part about what you said, Mary, and again, obviously these are being done over the phone, so it might be better for a face-to-face visit. But the tricky part is if you leave your assets to one person, that person actually gets everything. So the job of dividing them really goes to the executor, and then you should probably list out everybody you want to get them. Otherwise, the money goes to that one person, and they get to keep the assets.
That's true.
Whether or not they distribute it would be up to them, and they'd have then it would be gifting and so forth. So if you're the one who should really make the direction as to where you want the money to go, and then put it in writing in your will so that we know that that's going to happen.
Right, and especially like you were talking about the tax consequences, if they are the only beneficiary and they're inheriting your 401ks and IRAs, then that tax consequences falls to that one person.
Yeah, I mean the instructions would be that she would then.
But unfortunately, if she's the beneficiary, she's going to get it all, so it's all going to be taxable to her.
And she could take that out of the estate, though.
Well, again, it would be tricky. So my advice, just in general, and then actually in particular for you, Mary, but just in general, would be if you want money to go to multiple people, we really need to direct it to all those people by putting one name on as either a beneficiary at your IRA or beneficiary under your will. That can create unforeseen consequences, and one of the things we're trying to avoid with a good estate plan is unforeseen consequences.
Right.
Okay, but is 62 too early to start putting those things in place?
No, absolutely not. I mean, we want to get the plan in place just in case something happens.
Yeah, just
tomorrow.
because somebody's a beneficiary, isn't it true that you can have like 5 beneficiaries on a 401k plan?
Absolutely, 5, 10, however many you want.
If you have 5 relatives, there they are. Everybody's going to get 20%, but it's still your money until you go away.
Correct.
Right.
And as we talk about our IRAs, just to add so everybody understands, for many people, the largest asset that they own is their IRA that you've accumulated through work as saving it with a 401k that's now being distributed when you pass away. The beneficiaries get that asset, and there's important tax consequences. There's ways to protect that by stretching it out into a stretch IRA. So the use of beneficiaries on the IRA is a very important decision and a big part of the estate plan.
Okay, Mary?
Thank you very much.
Thank you, dear.
Yeah, it's so funny that she said is 62 too young to plan. I was at my mother-in-law's yesterday, and there was just 2 days ago, a 50-year-old cardiologist died of a heart attack in Buffalo. I'm trying to think of his name. But anyways, you just don't know.
Well, my sister-in-law,
Yeah.
my sister-in-law, my sister-in-law's son's mother-in-law. How's that? That's how it works. They just had the wife of her son had just had a baby, and they were at their mother-in-law's house, and the mother-in-law went downstairs to do laundry, and the mother-in-law was 42 or 43, and she didn't come back up. They went downstairs, and she was dead.
Yeah.
I mean, you don't know. You just don't know.
And therefore, the timing, when you use the age 62, there's really, you got to have the estate plan in place because you just don't know.
That's exactly right. I'm Esther Gulius, the tax lady from EG Tax. We have Jeffrey Katz, an elder care attorney, here in studio. Excellent advice. Gives you a great opportunity to kind of ask those questions you'd like to ask. We're going to take a short break. We'll be back with your calls on the other side. Hey, I'm Esther Gulius, the tax lady, and we're talking about getting old and moving your assets and Medicaid and Medicare. And we have Jeffrey Katz, our wonderful friend and elder care attorney here in studio, wants to help you. All right. But we were talking in the break about, I have seen that a person has only one beneficiary, and she says, now when I pass, I'm going to leave it all to you, and you're supposed to give it to all the rest of the kids. And that burden falls on that one person. And if they don't want to gift it, they don't have to.
No.
Morally, maybe they should, but they don't have to, and they don't always.
Or I just did an estate return for somebody, and the assets for that person should have been distributed beforehand, but it went into the trust, and then they distributed it. So they had a $50,000 IRA, and the tax that they paid on it was about $15,000 to the federal and about $4,000 to the state. So had they distributed it before the trust got their hands on it, the tax consequence
because the tax consequences
would have been so much
higher on a trust.
Yeah.
Let's go to Sue in Williamsville. Hi, Sue.
Hi. Good afternoon.
How can we help you?
Oh,
you're welcome.
I'm wondering if you distribute your assets to various family members, and then let's say 6 or 7 years later you need to go into assisted living, and you're applying at these facilities, if they see that you really don't have enough assets in your name,
will they let you in?
Accept you?
Well, Sue, that's a great question. First off, for assisted living, because there's two different types of long-term care facilities. One is assisted living, which generally does not take Medicaid. That's really always on private pay, and that's a lower level of care than what would be a skilled nursing facility or what commonly called a nursing home. So assisted living basically is always going to be private pay, and they're certainly going to need to see you have enough money or your loved one has enough money to pay the bill month after month. And those run, just on pull out a number out, like $4,500 a month to live in an assisted living facility. When you do apply to a nursing home, certainly people who are private pay, generally speaking, go to the front of the line because a nursing home will make more money or have an ability to charge more for a private pay patient than they would for somebody who's on Medicaid.
So as Sue said, she's going into the nursing home. She has no money, and so maybe she would be at the back of the line because she's using Medicaid?
Well, actually, she was talking assisted living.
Yeah, assisted living.
She wouldn't get into assisted
living. We need to have the cash available. For a nursing home, potentially, certainly private pay. There are advantages to being private pay, but, of course, you're spending your own money.
Does that help, Sue?
Yes. It gives me some pause to think that you wouldn't really want to transfer too much of your money to family members to make.
Well, there's all kinds of ways. Like, for instance, if you have, correct me if I'm wrong, Jeff, let's say you have CDs, can't you do payable on death?
Well, there's certainly, there's things to, we can use payable on death or transfer on death, which would distribute the assets at death. If we are looking to asset protect to try and protect the assets in case of nursing home care, we could set up a trust, transfer the assets to trust with certain provisions that are in there. So, Sue, there are ways to protect the assets, but yes, everything comes with pros and cons. There's nothing that's absolutely perfect to solve these problems. And what you have questioned is one of what would be a con for transferring away all your assets for sure. So.
Okay, Sue.
Okay, thank you,
dear. Thanks for calling.
Good question.
I'm Esther Gulias, the tax lady from EG Tax. We have Jeffrey Katz here, an elder care specialist and attorney, and we're taking your phone calls, and we're going to go to Joe in Williamsville. Hi, Joe. Hello, Joe.
Hi, how you doing?
Good.
My question is, I'm a little confused. In other words, what is the purpose in setting up a lifetime estate to protect assets when, in fact, if you don't do anything, the person that's left can have the house, as you said, and $90,000 in cash? What's the advantage to a lifetime estate then?
Okay.
You mean on a house?
Pardon me?
On a house. A life estate is on your real estate, your house.
Exactly.
Okay. So what's the benefit?
Okay. So we call it a life estate or a deed with a life estate. What it basically means is we'll use Mom as an example. Mom's alive but getting older, and her goal is to make sure that the house gets passed to her children And if she sets up what's very common, and we do it all the time for clients, is we do a deed with a life estate where we would transfer the house from mom to the kids. Now the kids assume ownership of the house, but mom has a life estate, life interest, life tenancy. What that means is that she continues to live in the house. She pays the bills. It remains her home for all practical purposes. She continues to get property tax exemptions on the home. But after a period of 5 years, if she did need long-term care and need to go into a skilled nursing facility, then that home would no longer be counted as her asset, and it would be protected so that if she was a single individual, because remember, Joe, I think that's part of your confusion, if you're a married couple, the house is automatically protected if there's a community spouse. If dad was living at home while mom went into the nursing home,
There's the difference.
The house would be protected. If dad had passed away and it was mom alone, then the house would not be protected, and the house would have to be, in essence, spent on the nursing home care. So that's the difference that I think hopefully we can everybody can understand.
Okay, Joe?
One more short question.
Yeah.
If you do set up a life estate just on the house, and as I take it, the person that does that owns the house, continues ownership of the house, but the trust, of course, has to approve anything and everything that's done. If you wanted to apply for a home equity loan or a line of credit or whatever, would you be able to do that?
Basically not, because when the house has been transferred, again, let's say from mom to the kids, to get a home equity loan becomes much more complex because mom no longer, if she's the one who wants the home equity, she doesn't have full ownership of the home. She's transferred it to her kids. So the only way to get that, a home equity, would be to get an institution, a bank, to agree, and it would involve all the party members. So generally speaking, when we're talking to clients, if they're going to need a home equity, if they're going to need to go apply for a mortgage or refinance their mortgage, we're not likely to do a deed with a life estate because of the added complexity. You'd have to get a bank to agree to loan it on those terms, and in that situation, most times the family wouldn't want it or need it. So,
well, the bank, but if the trustees and everybody agreed, the bank could then grant it.
The bank could grant it. We'd have to get the bank could do that, and if they did it, then all the parties, whether it's the trustees or the individuals who own the property, the person with the life estate, would have to be signing on in the home equity transaction.
I see.
Okay.
Well, thank you very much. Very helpful. Thank you.
All right, thanks, Joe. I'm Esther Gulias, the tax lady from EG Tax, and our whole thing is to help you in all of your phases of life, and this part, what we're talking about today, planning for the unfortunate time that you might become ill, your spouse might become ill, your mom or dad are getting older. These are so important, these kind of decisions, and the conversations. So many times clients will come to see me, Jeff, and they'll say, I know I should talk to mom about it, but I don't want to upset her, and it's so sad because let's say mom has $300,000 in the bank, and then she goes into a nursing home at $180,000 in a year. It's gone.
It's hard, and it is hard to have those discussions, Esther. But I think as you know, because you see so many people, it's so important for families to do that. I would always urge them to meet with the right person, to have those discussions, because if you don't, before you know it, it's too late.
That's true. And then there's nothing. And again, I'll say to my clients, do you want anything to go to your children? Because if you really want to be a private pay patient and you want all the money that you saved to pay for your nursing home, that's your decision. But many times people don't know that they really don't want that, and they haven't planned, and so that's the problem.
And there's options available.
Let's go back to our phones. We'll talk to Mike. Hey, Mike, how can we help you, sir?
I was wondering, I have two siblings. I have no children, and I want to leave my estate to my best friend.
Okay.
Mm-hmm.
Is there a vehicle that I can use where it's not going to be contestable?
Okay. Well, first off, you have the right to leave your assets in any way to your best friend, to anybody that you want. Family members may have a right to contest, but if it's done appropriately, they would lose that contest. there are some vehicles that are better than others to limit the ability to contest. A trust might be that example. So there's a difference between a will and a trust in terms of how to distribute the estate. And for that, you might want to talk to an attorney who could set up a trust for you. I've been writing trusts for clients for 30 years, and there's certain reasons to do it. And one of those is if you're worried that your estate's going to be contested.
Oh, I'm quite sure that they would do that.
Well, then you should certainly see somebody and to make sure that your estate is done in such a way that their ability to contest would be decreased. They'd probably lose anyways, but at least you just want to save the headache for your friend. So.
What a great example! Now I will never forget why use a trust. That makes sense.
Yep, that's one of the significant reasons. Yep.
Okay, Mike.
Thank you very much.
Thank you, sir. Okay, let me ask you a couple questions, Jeff. So, let's say that the vehicle that somebody might want to have, like Mike, is to use a trust because he has nobody right now to gift it to. He probably doesn't want to give his money to his best friend,
Correct.
right? So, what is a trust and how does it work?
Okay, there's first of all, there's really two types of trust. One is a revocable trust, and the other is an irrevocable. So a revocable trust is what would be called by the IRS a grantor trust, that the person retains control. So somebody like Mike, for example, he'd set up the trust, he'd be the trustee. The assets would remain his for tax purposes, for control purposes. It would just be using a trust instead of a will to distribute the assets when he dies.
Okay.
So that would be one type of trust.
Right.
The other would be an irrevocable, where a person gives up control. That would be done, as we've been talking about today, in the elder law context.
Right.
Try and get assets out of your name, out of your estate, so that you no longer have control.
So on the revocable trust, right?
Correct.
That means it's you still retain the assets.
Absolutely, still your money. It's really just an alternative to a will.
It's the irrevocable trust that that's it. You gave it up, and how much can you put into the irrevocable trust?
Well, the irrevocable trust